Thanks, everybody, for being on the call. I just wanted to start by introducing our speakers. These are really two of the, I think, most interesting, thoughtful, effective people working on this right now, and I really appreciate them both being on the call with us to share their insights. Gavin Rooney is a partner at Lowenstein Sandler. He is the chair of the class action litigation group there, and he specializes in class actions and complex commercial litigation. He has handled many, many TCCWNA class actions and has also done several amicus briefs on TCCWNA issues on behalf of New Jersey Civil Justice Institute, including currently pending cases in the Lumber Liquidators case, which is pending in the appellate division, and the Dukan case, which is currently pending at the New Jersey Supreme Court. Jeff Jacobson is a partner at Drye, where he defends consumer, privacy, and securities class actions and general commercial litigation. He is the former director of New Jersey Division of Law and former chief counsel to the New Jersey Attorney General. He also has handled several TCCWNA class actions and argued the TCCWNA case, the Dukan TCCWNA case, at the New Jersey Supreme Court on behalf of New Jersey Civil Justice Institute when Gavin had a scheduling conflict. So we, again, appreciate the work that both of them have done on behalf of New Jersey Civil Justice Institute and appreciate both of them being on the call today. The plan for this call is for Gavin and Jeff to begin by giving an overview of the major questions that are currently being addressed in New Jersey and federal court, where the federal and state courts have come down thus far. Also give a sense of how the recent oral arguments have gone and thoughts on future developments. And then we will open for questions from the audience. So with that, I'm going to turn it over to Gavin to begin our call.
Thank you, Alita. This is Gavin Rooney. I appreciate the opportunity to speak to you all today. Let me just start by setting the stage a little bit with background in history about the Truth in Contract Consumer Warranty Notice Act, which I'll call TCCWNA for short, probably the world's ugliest acronym. As many of you probably know, it was passed by the New Jersey legislature in 1981. It is, to my knowledge, unique in the United States. I don't think there's any other state that has anything like it or even, frankly, remotely like it. It was meant to prohibit sellers from putting provisions in their contracts which violated consumers' rights and provides for a civil penalty of $100 in the event that an aggrieved consumer can bring a claim that a contract had something that violated his or her rights. It sat forgotten on the statute books for several decades. It was discovered by the plaintiff's bar in the late 2000s. And at that point, the statute was married to the class action device, where the approach of the plaintiff is to find a form contract signed by a large number of parties, which the plaintiff then says has an illegal provision in it. And then the plaintiff files a class action seeking that $100 civil penalty for everyone who signed such an agreement. TCCWNA therefore joined some of the other no-injury statutes that are the subject of a lot of class action litigation in the federal courts today, such as the Telephone Consumer Protection Act, the Fair Credit Reporting Act, and others. The TCCWNA class actions that have been filed since the late 2000s into the current decade, in my view, have really gone through a couple of phases or stages. The first phase was focused on door-to-door sales practices or brick-and-mortar facilities where the consumer was asked to sign a physical contract, usually which was part of a form, and then a class action was later brought by a disaffected consumer who claimed that the provisions in the contract violated their rights as a consumer. That first phase of litigation led to a second phase of litigation that really came to the fore in 2016, and that was moving from the brick-and-mortar context with a physical contract to online retailing and websites that offered a terms of use or privacy policy often really just posted on the website for informational purposes or as part of a browse wrap sort of situation, where the plaintiff alleged that there was something buried in the terms of use or in the privacy policy that violated someone's clearly established legal rights. I kept count of those last year, and by my count, at least 50 of those website terms of use cases were filed in 2016, and those cases are now wending their way through the courts, as we'll discuss during this call today. So there's been an explosion in TCCWNA class action litigation over the past few years in these two different phases of cases that I've talked about. And the trial and appellate courts are now really beginning to come to grips with some of the key issues under the statute. And those are the issues we're going to talk about here today. The first issue is under Section 15 of the statute. What does it mean to say that a provision in the contract has violated a, quote, clearly established, close quote, right of a consumer? What does that mean in order to establish a violation of the statute? Secondly, under Section 16 of TCCWNA, what does it mean to say that a provision is void, unenforceable, or inapplicable in some jurisdictions without advising whether it's enforceable in New Jersey? And then finally, and perhaps most significantly overall, what does it mean for a consumer to be aggrieved within the meaning of Section 17? The $100 civil penalty that I mentioned before is only available to a consumer who is, quote, aggrieved, close quote, by virtue of a Section 15 or Section 16 violation. And what does that really mean? Does it simply mean that someone was a party to a contract that had a provision that a plaintiff says violates one of the other sections of the statute, or does it mean something more in terms of actual real injury? As Alita mentioned before, the New Jersey Civil Justice Institute has submitted amicus briefs in the pending appeals, which are starting to come to grips with some of these issues, as we'll discuss today. Jeff?
So this is Jeff Jacobson. It's also a great pleasure to be with you and to be with Civil Justice. There, as Gavin mentioned, there are a lot of class action cases that were filed both in state court and then removed to federal court, and some that were filed in federal court originally. A lot of those cases, nothing has happened. Part of the reason nothing has happened is because the Third Circuit, in the first wave of cases, certified two questions to the New Jersey Supreme Court that the New Jersey Supreme Court did not decide until about 10 days ago that they were going to take. After the Third Circuit announced that it had certified those questions, several federal district judges formally stayed their cases awaiting word from the Third Circuit and the New Jersey Supreme Court. Those include cases against some of the largest retailers in the state, including Walmart and Toys R Us. And so the effect of those judges' rulings has been not entirely but largely to freeze the playing field. There have not been a lot of new cases filed, and you're not getting a torrent of decisions from district courts while the New Jersey Supreme Court and Third Circuit process is being completed. But we already have a number of decisions that trickled out before the Third Circuit took that action, and even some since. And the general pattern is good for defendants. There, with one exception, there have not been any smashing wins for the plaintiff's side in TCCWNA motions to dismiss. Most of the decisions have ended up being dismissals on several bases. One of those bases is if your website terms of service has a choice of law clause that you can defend. In a case called Palomino against Facebook, a judge in the Northern District of California upheld that choice of law clause in Facebook's terms and said that a New Jersey plaintiff can't bring a TCCWNA claim because he agreed that any dispute he has with Facebook would be settled under California law. A couple of cases have been decided on the basis that TCCWNA does not protect you from omissions, that it only protects you from affirmative statements. There is a case, it's an unpronounceable plaintiff that I think I'm going to get wrong. It's Jacobson against P.C. Richard. The Judge Walls started this trend in June of 2016. There have been a couple of decisions since then affirming that you can't bring a TCCWNA claim based on an omission. A couple of judges have said what would seem to be perfectly obvious. Gavin mentioned the aggrieved consumer standard, and we'll talk a little bit more on this call about what it might mean to be aggrieved. A couple of judges have said at the very least you have to have at least read the language that you're claiming aggrieved you. And so in a case called Friest against Luxottica, Judge Wigginton said if you haven't read the language, you don't have a claim. And that has been echoed by a couple of other judges since Judge Wigginton made that decision last December. A major basis, and I saved this one for last, has been the Spokeo decision. As you all may know, the Supreme Court a year ago decided a case called Spokeo, holding that a bare statutory violation untethered from actual harm in the real world does not get you Article III standing. And although the standard for Spokeo and the standard for aggrieved consumer to get you statutory standing should probably be the same, federal courts have an easy out here. If they find that you don't satisfy Article III, they just kick you out. And then they don't have to address anything else because you haven't passed the Article III prerequisite to get into federal court in the first place. So there have been a number of decisions, at least 4 that I could count, without doing any real looking into it, where judges have bounced these cases on Spokeo grounds. There's Candelario against Rip Curl from the Central District of California, and then there have been 3 or 4 New Jersey decisions, Rubin against J. Crew from just a couple of weeks ago, Haidt against Lush Internet from just a couple of weeks ago, and of course the Wenger case that led to the Third Circuit certified questions. But even as judges have dismissed those claims under Spokeo, they have ripped into the plaintiff's bar. I mean, these are not, gee, I wish I didn't have to dismiss these wonderful claims under Spokeo. These are terrible claims, and I'm glad Spokeo gives me a chance to get rid of it. And I want to commend to your attention particularly Judge Wolfson's language in the Rubin against J. Crew case, which I will read because I can't do it justice unless I'm reading it verbatim. While the intent of the New Jersey legislature in enacting the TCCWNA is to provide additional protections for consumers in this state from unfair business practices, the passage of the act is not intended, however, for litigation-seeking plaintiffs and or their counsel to troll the Internet to find potential violations under the TCCWNA without any underlying harm. In such instances, standing would be lacking. And then the judge proceeded to kick out the case. As I mentioned, though, there is one loss, and that loss came from the Western District of Pennsylvania about 2 months ago in a case called Luca against Wyndham Worldwide. It has a lot of similarities to the case that the New Jersey Supreme Court just heard on April 4th that Gavin and I both will talk about. What the judge held in Luca is that Spokeo was satisfied because the plaintiff alleged that, look, I went online, I entered into a transaction with Wyndham. Wyndham didn't accurately state the total cost of what I was going to pay because they did not adequately disclose that they were charging a resort fee. Therefore, I have a claim both under the Consumer Fraud Act and a claim under the TCCWNA. And the judge held, look, you had the transaction. It didn't include the full price, so you state a CFA claim. I find you're sufficiently aggrieved under the TCCWNA, and because you are, you satisfy Spokeo. So it has not been a clean sweep for the defense in these cases, but it's been almost a clean sweep with judges expressing absolutely no patience for these kinds of claims, particularly by people who did not read the terms and clearly suffered no injury. But, we're going to transition now to talking about what's going on in state court, and I want to caution people, and I know Gavin will echo this, that although these federal decisions have been terrific, ultimately these questions are going to be settled in state court, either because, by virtue of the Spokeo dismissal, plaintiffs at least theoretically have the right to refile these claims in state court, but more importantly, what the New Jersey Supreme Court says about this is going to have a major impact on the federal jurisprudence moving forward. So with that, I'm going to hit the ping-pong ball back to Gavin.
Thanks, Jeff. And let me start talking now about some of the key appeals that are going on right now in the New Jersey state courts that will, over the next few months or over the next year when those appeals are decided, give us some indication of what the key language in the statute means and what impact that may have on the future of these class actions. The first case I wanted to talk about was argued to the appellate division last fall. We're awaiting a decision. It's called Kaufmann versus Lumber Liquidators. This was, to me, an interesting case. The claim in the case is that the plaintiff had purchased hardwood flooring from Lumber Liquidators. The plaintiff claimed that hardwood flooring qualifies as furniture within the meaning of the household furniture delivery regulations. And then he went on to claim that the terms of service that were provided to him failed to comply with those regulations. the key issue that was debated at the trial court level and then before the Court of Appeals was whether hardwood flooring is or is not furniture. Obviously, the defense took the position it's not something you pick up and move when you leave, when you sell your home. It's a fixture, and it's not furniture. The plaintiff argued, well, it's close enough to a throw rug that it should be qualifying as furniture under the statute and under the regulations, especially given the pro-consumer and consumer protection purpose of liberally reading the regulations in the statute. The Civil Justice Institute submitted an amicus brief in that case, and our amicus brief there was really focused on using the facts that I just described to illustrate what clearly established should and should not mean. The argument we developed was to look to another body of case law that has applied the clearly established standard, and that's the body of case law that gives individuals sued on civil rights claims immunity from suit, provided they did not violate a plaintiff's clearly established civil rights. In other words, if a police officer or a municipal official is alleged to have violated someone's civil rights, it really has to be a clearly established civil right that police officer or a public official ought to have known better, not something that might be arguable. There's a pretty well-established body of case law defining that and defining it in a way that is really meant to protect individuals as opposed to public entities that are sued on 1988 or civil rights claims. And so we argue that the language is the same, the standard essentially ought to be the same, and it should be applied here. And in particular, we broke it down by saying clearly means it's essentially beyond debate. It can't be subject of reasonable disagreement. In layman's terms, it has to be a no-brainer in terms of the fact that the provision at issue violates the consumer's rights. Secondly, in addition to being clear, it has to be established. In other words, it has to have been established in the law by statute, judicial decision, or otherwise at a time before which the contract at issue was entered into. So applying that standard to the facts of the case, we explain that given the length of the argument as to whether hardwood flooring is more like a throw rug or more like a fixture, putting aside what you think of the merits of that, it could not possibly be clearly established, both because it's subject to reasonable debate and both because the plaintiff could not point to any prior precedent indicating that before the contract was entered into, hardwood flooring was considered a furniture. So I think, that's a set of facts that hopefully will be able to give the appellate panel an opportunity to explain to us what clearly established is in a helpful way. The other thing I'll just pause and note about lumber liquidators before moving on is that the outset of the argument, and this will be a theme in what we talk about today, the judges were clearly focused on the fact that no one's actually been injured here, and in fact that was the first question to the plaintiff's lawyer during the oral argument, and that really affected everything as Jeff mentioned before with some of the federal cases. Let me move on and talk about another set of appeals that are addressing a different section of the statute, Section 16. That, of course, is the section that says a contract may not state that certain provisions may be void, unenforceable, or inapplicable in some jurisdictions without specifying whether the provisions are or not enforceable in New Jersey. There was a consolidated series of appeals argued to the appellate division a couple weeks ago, 4 cases in particular that addressed this question and what the scope of that might be. And in particular, what the cases looked at was the use of common qualifying or limiting or incorporative language that we all see commonly in forum agreements, such as unless prohibited by law, where prohibited by law, to the fullest extent permitted by law, or as permitted by law. Do those phrases, any one of them individually or any of them together, indicate a violation of Section 16? And that's an issue that the courts have trying to grapple with. The issue in most of these cases in particular was a provision on the back of a retail order to purchase or lease a car that said the purchaser or lessee will pay all taxes attributable to the transaction unless prohibited by law. And the plaintiff said, aha, that's a Section 16 violation, and therefore every person who signs such a contract is entitled to the $100 civil penalty. Again, we're awaiting a decision from the appellate division on those consolidated appeals. The argument we presented there was that the phrase some jurisdictions in the statute means that enforceability has to vary among states as a matter of geography, and that language that does not infer a difference in enforceability among the several states according to their common law does not run afoul of Section 16. So language that's meant to conform, comply, or incorporate existing law is different and does not run afoul of the statute, and the phrase unless prohibited by law in the context of this provision is exactly that. The other interesting thing that came up during the argument is while it was not argued below, the appellate panel was very focused on the question of what does it mean to be an aggrieved consumer, and I think was concerned with the fact that this was language found on the back of a retail order by the plaintiff's lawyers by happenstance, which they were trying to turn into a $100 civil penalty. And the question was really focused from the appellate panel on whether confusion alone is sufficient for that. Is it enough that the language is confusing? And if so, does that confusion have to be objective? Would it be confusing to the reasonable person? Or subjective? Was it confusing to the actual named plaintiff? And would that have to be pled and proven in order to establish a claim? And that really, I think, introduces us to our next discussion about aggrieved consumer, which feeds off of that, the Dukan case. Jeff, you want to talk about that for a few minutes?
Sure. So the Dukan case, the issue in the Dukan case is if you walk into any TGI Fridays restaurant or you walk into any of the various restaurants run by OSI restaurant partners, you will find that drink prices are not printed on the menus. And there is a provision of the Consumer Fraud Act which says that if you sell goods at retail, you have to place the price conspicuously where the goods are offered for sale. And the plaintiffs contended that that provision applies to restaurants and applies to drinks served at restaurants, and they sued under both the Consumer Fraud Act and under TCCWNA. And during discovery, the plaintiffs unearthed a survey, a marketing study that the TGI Fridays performed that said that they could get an average of about $1.20 more per drinks if they didn't put the drink prices on the menu, and that they said, well, aha, that's why they didn't do it, and that was going to be how they were going to come up with ascertainable damages under the Consumer Fraud Act. The case made it to the Supreme Court on the question of whether a class can be certified. A trial judge certified a class here basically saying that anyone who was presented with a menu that didn't have a drink price on it is a member of a TCCWNA class and a Consumer Fraud Act class. The appellate division reversed, holding that no, it's not. First of all, we can't prove with common evidence that anyone actually was presented with a menu, because somebody could have just walked into the bar and ordered a drink without seeing a menu. And so simply on the basis that they can't prove presentment with common evidence, a class could not be certified. And the Supreme Court agreed to hear the case on an appeal from the appellate division's reversal of class certification. This is an example of the work that New Jersey Civil Justice Institute does to make sure the law is shaped in the right direction, because until I had the privilege of standing up, nobody mentioned TCCWNA during the oral argument. The plaintiff's entire opening oral argument focused on the Consumer Fraud Act, and the defendant's entire argument focused on the Consumer Fraud Act. And if you walked into the courtroom and heard only those two arguments, you would think that this was a case about $1.22 per plaintiff and whether or not there was a way to prove ascertainable damages on a class-wide basis. And then, arguing for Civil Justice Institute, we stood up and said, well, wait a minute, there is a $100 hammer here called TCCWNA, and that's the damages hook in this case. It's not $1.22, it's $100 for everybody who crossed the threshold of this restaurant. And the job was to try to argue the two key questions that Gavin mentioned earlier: clearly established legal right. Nobody had ever held until the appellate division in this case that provision of the Consumer Fraud Act even applied to restaurants and to drinks at restaurants, so it couldn't be clearly established. And how in the world were you going to tell who was aggrieved? Because it can't be that simply seeing a menu makes you aggrieved, or even worse, if some of the amici on the other side had their way, simply walking into a restaurant where menus are displayed makes you aggrieved. And we knew that that had an impact on the justices, because when the plaintiff got back up in rebuttal, one of the justices asked, "So wait a minute, is this in fact a multi-hundred-million-dollar case?" And the plaintiff said, "Yes, it is." At which point you could have heard a pin drop in the room. I mean, there were justices with their mouths agape that they suddenly realized that what the TCCWNA means in this circumstance is you can put a business out of business simply by virtue of a notice violation. And this would be the first statute in the history of New Jersey where the legislature would have adopted a statute that says if you put up a bad sign, the damages can put you out of business. And it kind of changed the nature of the oral argument from then on. Justice Patterson started asking, so wait a minute, if a restaurant prints a list of specials on a blackboard and doesn't list prices, does that mean that restaurant could be put out of business? And the plaintiff said, yes, it does. They should print the prices. Justice Lavecchia asked whether there is, in fact, any other precedent besides the appellate division in this case for the idea that this law applies to restaurants and bars at all. Plaintiffs admitted that it didn't. So there are a couple of possibilities that can emerge from this. One is they can take the easy way out and say that there's no clearly established legal right that was violated here and bounce the TCCWNA claim on that basis and make the case simply about the CFA and not address certification standards under the TCCWNA. Or they can go further and discuss what it means to be an aggrieved consumer, whether somebody needed to have gotten a menu, read the menu, made a decision based on having read the menu. Because there were questions about that, and different justices had kind of different thoughts about whether or not you might be able to certify a class under the TCCWNA. But nobody was biting with the idea that this should be Steve Orlovsky, who was arguing the case for TGI Fridays, mentioned that according to the plaintiffs, there are some 1.4 million members of this class, and that therefore this is a major $100 for, I'm sorry, 14, I got it wrong. I moved the decimal point. 14 million people in the class, which means that in theory it's a $1.4 billion case. And, nobody really believes that there are 14 million people in the class, but under the plaintiff's own estimate, this case would be worth that, according to them. And as a result, the justices were transfixed by the idea that that's what the TCCWNA can mean here. And so stand by. I don't know what's going to happen in Dugan, but whatever it is going to be interesting. And this is really one where, those of you that who have been long supportive of the Civil Justice Institute, this is an example, and Gavin did an absolutely spectacular job on the brief. This is an example of the Civil Justice Institute really delivering for its members, because I think but for our ability to stand up as amici, this argument would have gone very differently, and the TCCWNA could have slipped in under the radar. But by virtue of Gavin's terrific brief and the Supreme Court's willingness to hear us as amicus, it definitely turned the argument around, and we'll see what happens.
Yeah, I also thought that Dugan was a very interesting case for the TCCWNA analysis because of the gross disparity between the price of the item at issue. Think of a beer for $5 versus a $100 civil penalty. And I think that really had an impact on the justices, too, as opposed to the absolute number, as Jeff mentioned as well. It really illustrates itself as a punitive measure, especially when it's married to the class action device. In terms of what we're looking at in the future, and some thoughts to conclude our prepared presentation before we switch to questions from the audience, we should certainly mention and emphasize another appeal that Jeff has mentioned that's coming up, and this is in the Spade versus Select Comfort Corp. And the Wenger versus Bob Discount Furniture LLC cases. Those were cases that were filed in the District Court in New Jersey They were dismissed on a motion to dismiss and a motion for judgment on the pleadings by Judge Sheridan, and then they went up to the Third Circuit, and the question there was whether a consumer who entered into a contract that's allegedly in violation, again, of the furniture delivery regulations that I talked about earlier, is an aggrieved consumer, and whether a violation of those regulations would violate a clearly established legal right. Rather than itself address those questions, the Third Circuit on appeal asked the Supreme Court of New Jersey to answer those questions for it, and the Supreme Court of New Jersey recently decided to accept that question and issued an order to that effect. So the matter is now proceeding to the briefing stage. But in addition to the Dukan case that Jeff described before, as we keep an eye on Spade and Wenger, that will be another opportunity for the highest court of the state to address the meaning of these important provisions going forward and what it really means to be aggrieved and to violate a clearly established right.
And the only thing I would add to that is just it cannot be a coincidence that they accepted certification of those questions 2 days after the oral argument. And whether that means that they think they're going to address the questions partly in Dugan, or whether it means that they now have to have their curiosity piqued and realize that they need to tackle this, the timing cannot have been coincidental.
And the other thing that came up, I should mention as well, in the earlier appellate division appeals that I mentioned involving the 4 automobile-related cases, when aggrieved consumer was discussed there, Judge Sabatino, who presided over that panel, asked about the status of the certified question to the Supreme Court. So I don't doubt he will then hold his opinion there to see what the Supreme Court says about aggrieved consumer in the Wenger and Spade matters when that is ultimately decided. So I think these issues are coming together in a variety of different cases at the appellate courts in New Jersey. Just to conclude with a few thoughts before switching to questions, as Jeff mentioned before, I think he's absolutely right that the key issue on these TCCWNA claims will be decided in the state court. The federal courts are largely sidestepping the substantive questions under Spokeo and not reaching the merits of these claims, and so that's why these cases in the appellate division of the Supreme Court are so important. I think Dugan and the Wenger case are so critically important in this area, as the Supreme Court of the state has the opportunity to tell us what aggrieved means. There are several different ways the court could define what it means to be aggrieved. The plaintiff's view, I think, is that it's simply enough to sign a contract that has an unlawful provision, because even if you haven't read it as a consumer, the fact that you're bound to a contract with an illegal provision is enough to make you aggrieved. Another way to look at it, as Jeff mentioned before, is that in addition to signing the contract, the class member at least needs to have read it, and a phrase that's buried on the back of a document that no one really reads, such as what was at issue in my car cases, should not be enough to render you aggrieved. Another way to look at aggrieved is whether the consumer was in fact confused or misled by the provision at issue, going back to some of the questions I got in the appellate division argument, though I think what would be important there is to make sure that it's subject to confusion, not objective confusion, that the named plaintiff himself or herself was actually confused or misled. And then I think the last way to think about aggrieved, and probably the best for defendants, is that in addition to signing a contract or having read it or been confused, that the consumer must have been adversely impacted by the issue in some way. In other words, it's not enough to just read the read the provision and say to yourself, boy, I don't know what that means, and then put down and never think about it again. It may not go so far as to actually constitute injury as you normally would think of it in the context of a tort claim that would entitle you to compensatory damages, but enough that it would actually have some meaningful adverse impact on you as the plaintiff in order to qualify as aggrieved. Maybe we'll open it up to questions.
What is the timeline that we should maybe expect to start seeing some answers in all of these cases?
Well, this is Jeff. I can start and Gavin can correct me. I think the first thing we will see is a decision in Dugan. It will come down probably in June, possibly sooner, probably not later. That decision may or may not answer the certified questions in Wenger and Spade. If it doesn't, those questions will certainly be pushed over to the next term of the Supreme Court. So we would expect the briefing to take place in the fall and the oral argument to take place in the late fall or early winter, with a decision coming out probably in early 2018, and the federal case is largely frozen in amber until then. Gavin, did I get that about right?
Yeah, I agree with that. The only thing I'd add is the appellate matters, the appellate division matters that I mentioned before. I would expect the Lombard Liquidators opinion at any time. In fact, I think at this point it's really overdue, given that it was argued last fall. The car cases that I argued a few weeks ago, I would imagine will take another 6 weeks. However, it wouldn't surprise me at all that the appellate division awaits the opinion in Dugan before issuing its opinion. So if that comes out in June, as Jeff predicts, then it may be shortly after that we see those opinions.
To what extent the submission of an affidavit by class members would be sufficient to clear some number of those hurdles and still permit a class certification conceivably?
Well, I don't think in federal court that'll work under the Third Circuit's ascertainability cases. Class members say so isn't enough. I mean, from my perspective, if you were to get affidavits from class members, frankly, my working assumption is you wouldn't get all that many. And, you would still be able to truncate or limit the size of the class substantially. But, when confronted with that situation in class actions, my normal argument is I'm not required to accept a class member's say-so without subject to cross-examination if I'm able to, show that perhaps they're stretching the truth, they're lying, or not being honest, or simply motivated by the desire to get a free $100. So the position I would certainly take is that the question in class certification is whether the element of liability can be proven by common class-wide evidence, not whether we could get people to come forward with individual evidence of their own that we're supposed to accept at face value. And that's antithetical to the class action concept.
And just to add to that, the issue of affidavits and ascertainability came up at the oral argument in Dugan. The plaintiffs tried to argue that it was they basically tried to argue that the defendants were trying to breathe ascertainability into New Jersey state jurisprudence and that the justices shouldn't have it. And they asked about ascertainability and whether an affidavit in this kind of a case should suffice. And they asked specifically about Judge Rendell's dissent in the Byrd case, where she said that, I don't think that there's a problem with people submitting affidavits because who's going to take the time to submit a bad affidavit in a case that's going to yield them a buck or two? And the answer back to the justices that I gave was, well, this is not about a buck or two. This is about $100. At which point I mentioned that my wife and daughters and I all dined at TGI Fridays, and that means that I could fill out an affidavit and get $400, and that's not the small dollars that Judge Rendell was talking about. So, this is another aspect of the silver bullet is if somebody mentions, hey, affidavits, I think that a response of, hey, $100 is not a bad response in this circumstance.
Okay, I have another question, sort of an open-ended question on to what extent both of you consider the Spokeo decision to be incrementally helpful, incrementally not helpful, or sort of it depends.
Gavin, you want me to start? Because
yeah, go ahead. Go ahead.
Alita knows I have strongly held views about Spokeo's relationship with the TCCWNA. Spokeo, look, basically, just to back up a minute, there were those that hoped that the Spokeo decision would be a major win for the defense bar, that the Supreme Court would issue a decision basically saying unless the plaintiff has actual real-world injury, there cannot be a suit. And the Supreme Court stopped short of doing that. They issued a much more nuanced decision that said if there's really no harm, there's no standing. But they left room for things like cases under the Telephone Consumer Protection Act where the harm is ethereal, but Congress defined it to mean, look, you're having an intrusion, and that's enough. So Spokeo was not a magic bullet. And with regard to the TCCWNA, you could have, reasonable people could disagree about whether there is ever a circumstance in which you could be aggrieved for purposes of the TCCWNA, but yet not have a harm that Spokeo would say gets you into federal court. So, given my druthers, I would rather argue these cases that the plaintiff is not aggrieved, because a win on that basis is a total win and the plaintiff could not resurrect the claim in state court. But the Spokeo door having been opened and the federal judges having been very happy to walk through that door and do less work, we're ending in a situation where a win on Spokeo grounds does not necessarily mean a total win. It certainly is not. A judge is not whistling happy birthday if the judge says you don't have any harm, and that's not a great way to go into state court. But if state court standards are easier, and the Supreme Court could certainly make them so, then an argument that I get out on Spokeo is not necessarily a total win. And the other thing that I need to add to this is, heaven help you if you get sued in state court, then remove the case to federal court and then bring a Spokeo argument, because judges have not liked that, and at least one defendant has been basically held in contempt. Because if you invoke the jurisdiction of the federal courts and then argue that the federal courts don't have jurisdiction, there is a speaking out of both sides of your mouth quality to that judges do not like. So Spokeo is a nice tool to have in the toolbox here, but if you have the opportunity to argue for aggrieved consumer, that's probably a better way to go, at least in my view.
Yeah, I agree with that completely. My fear about Spokeo when it was pending and after it came out is it really does away with the Class Action Fairness Act that allows us to remove these cases to federal court. Article 3 is a defense you can bring in federal court, can't bring it in state court. Standing rules in state court are quite different than Article 3 in federal court. So you end up just litigating these cases in state court, where you were the forum you were trying to avoid to begin with. And I agree that the best way to play the issue is to essentially collapse the analysis between Article 3 standing and aggrieved consumer. If they essentially mean the same thing, and that to become an aggrieved consumer, you have to have something approaching what's required for Article 3 standing in federal court. Then you get a dismissal on the merits, and then it doesn't necessarily matter which of the two court systems you're in, and you're begun to set a series of precedents that will limit the effect of these cases long term.
Since it is going to be so long until we hear from the courts, is there something businesses can do in the meantime to protect themselves from these cases?
There's a couple things you can do, and I do this all the time. I'm confident Jeff does too.
Yes.
We take a look at contracts. We take a look at the backs of tickets. Yesterday, I was asked to take a look at the back of a ticket for a public concert to make sure there was nothing on the back there that would draw the attention of the plaintiff's bar in these TCCWNA matters. We take a look at online terms of use and privacy policies all the time. There's been enough of these cases around that it's at this point relatively straightforward, I think, for us to look over what's there and flag potential issues that might result in a lawsuit being filed. So that's an ounce of prevention that you can certainly take, and something I'd commend to everyone. Secondly, and I'd be interested in Jeff's view. I think the new filings have subsided substantially, and I think some comfort can be drawn from that. The other thing I should mention is that in addition to the filings, there were many more demand letters that were sent out. And I think, given the dismissals in federal court and and what's gone on in the certified questions to the New Jersey Supreme Court, if a demand letter, not a lawsuit, but a demand letter lands on your desk, that allows you to take a harder position with the plaintiff's lawyer who's sending it, because in light of the substantially lower number of filings these days, I suspect that the plaintiff's lawyer is probably not going to be interested in investing in new cases. What do you think, Jeff? No,
that was the second thing I was going to add, and you beat me to it. I think that torrent of cases has subsided, demand letters are still being filed. I've at least seen more of them coming out of counsel in California. I agree with Gavin that they are comparatively unlikely to associate with local counsel and file those cases here while they're waiting to see what happens. On the other hand, look, there is still a price one could pay to make that letter go away, but I completely agree with Gavin that the way the situation is unfolding, I would not pay a lot of money to make one of these demand letters disappear. I think there is something to be said for staying the course and seeing what the Supreme Court does. The body language in Dugan was positive. The fact that they took the certified questions immediately thereafter, I don't know what they're going to do, and I certainly don't think that they're going to let the restaurants completely off the hook under the Consumer Fraud Act. But if they take a whack at TCCWNA in the next couple of months, that could be just about the ball game.
And Gavin, would you say that lines up with the sort of the sense that you had thinking back to your oral argument in Lumber Liquidators?
Yeah, I think so. There's one thing that permeates most of these arguments is that the courts recognize that no one really was injured here. This is a technical violation. It's a gotcha moment where someone's alleging that a $100 civil penalty is owed. Some of the earlier cases that really seem to develop some legs, like Martinez-Santiago against Public Storage, the Judge Simandl case, involve different facts where, in that case, the violative provision was actually enforced against the consumer. And as a counterclaim, the consumer brought the TCCWNA violation. So it was, in terms of the merits and the equities, kind of a very different situation than these more recent cases where it's purely a gotcha moment based upon a technical violation. And the lack of any injury, I think, permeates the argument and the way the courts think about it. I think the justices during the Dugan argument were really legitimately concerned that, while this statute perhaps has run a bit amok thus far, if the plaintiffs get their way in Dugan, it will really run amok with becoming a weapon that could put a lot of companies out of business, and especially small businesses that are important to our economy, and they clearly had sympathy for that, especially given the fact that there is no injury.
I'll just put it back to Gavin, you and Jeff to see if you have a couple final closing thoughts.
Stay tuned. That's really all I can say.
Yeah, it'll be an interesting 12 months in this area.